Today's topic about bar council written exam, and I am so sorry come back so late because after completing my personal work and today's I am so busy for purpose of my legal life practicing in court. How to pass from the bar council written exam? This is the very pain, painful or panic and very very tensions for students who are get the prepared who are getting the preparations for bar council written exam, because this is the very important to win from this exam, and seven subjects are very important. There is no options avoid another or one or two subject, because seven subjects are very important. Joining Sagar Kumar. Thank you very much, and thank you very much to all viewers who are connected with live sessions and still with me listening and hearing about my speech. Or and thank you very much. I hope that and I expect from you and your advice and send me as a comments in comment box. Thank you very much. Actually, number one, thought of analysis. Number two, thought of memorize. Memorize, it is very easy way to pass, but there is not enough. 95% granted being passed from any exam or from bar council written exam. Memorize is very important part, but you have to analysis about these sections which is are those are very important and coming for the exam, because written exam provide that you have to you have to write, and the third of the sections which is required or acquiring from the section. Number one, penal code, CRPC, CPC, the code of the civil procedure, SR Act, Specific Relief Act, Limitation Act, bar council rules and order. Arising questions, murder and not amounting murder, different or different between murder and not amounting to murder, analysis that with example. This is the questions of bar council exam, and how to write the answer of the questions, and how to analysis the those sections, distinction between murder and not amounting to murder of penal code with example. This is the most important, very essential, because written exam provide that always analytic or analyze the questions with example. Number one, section 300 definitions of murder and punishment, section 302 of penal code, death sentence or lifetime imprisonment, but not amounting to murder, section 304 Section 304, punishment of culpable homicide and definitions identified in Section 299 of Penal Code. Limon Shamadgar joining with live sessions. And the candidate of Bar Council written exam who are interested to join or get the admissions as a member of Sharul Academy, I hope that from Sharul Academy and shortcut format, it will be applicable for the purpose of the exam, and I hope that shortcut format it will be helpful to pass and to carry the marks from the Bar Council written exam. Thank you, Shofik Bhai, but I am not connected and not. I am so sorry. Not call back with you to you, and next time I will call back. Thank you. Number one, Evidence Act. Evidence Act, oral evidence and documentary. What is oral evidence? What is documentary? And Section 6 of Evidence Act, res gestae. What is res gestae? How to connect with criminal case. Number one, murder case. Victim A, deceased person, and victim killed by accused number 1, accused number 2, number 3, 4, 5. 5 persons accused are connected with the case under section 302 of Penal Code and kill the victim. First time, identify intention, pre-plan, and eyewitness. It will be provided that how to identify the ingredients of this section. Because this is the very essential and for every students who are be worried or be tensionable for upcoming Bar Council written exam. Advice for all students. Number one, 7 subject, memorize then analysis. Not enough memorize the section, you have to find out legal thought of this section because written in the paper book or exam paper. This is the very important because by writing in exam paper, find out the analytical thought of the section. In use of this section arising of the fact because it is directly or indirectly connected with the case, and the sections provide that it will be preferable for doing act by the accused or not. Number one, recovery documents, section 27 of Evidence Act and section 103 of the Code of the Criminal Procedure 1898, making seizure list. At place of offense, local 2%, honorable 2% must be present making the seizure list. Otherwise, making seizure list, it will be not relevant for the purpose of the case and never applicable against the accused petitioners, because when the honorable court convicted the accused petitioners with the supporting documents which is the submitted before honorable court by the prosecution. And thank you very much to all viewers who are connect with me or live sessions, and comments your opinion in comments box. I hope that this is the great opportunity and for me. Number one, carry marks from exam paper. And how to carry marks from exam paper? Because number one, be prepared and good writing skill in Bangla, and arranging the thought of the as a questions of the require or query sense of the sections, it will be very important. Find out or analyze the thought, query thought of the questions is written in exam paper, because there is not sufficient there is the sufficient time, fixed time, 4 hours, and for the 7 questions, because memorize the sections of the law or code and with analysis the sections, ingredients of the sections. This is the essential, and it will be helpful for the exam, because written exam is not easy, and to carry marks by memorize have to know, find out legal thought of the section, because allegations, ingredients of this section, it will be applicable against the accused or not, because the honorable court convicted the accused with relevant documents before find outing or analysis the documents, which is the essential for the purpose of the case. Then this evidence to support the court and getting the decisions, being guilty the accused or not for the purpose of the case. I have one book for in criminal law, and I hope that this book, written this book and clear thought, get the thought clear sense in your practice life, it will be helpful. Some students ask me how to carry the marks from the exam. From me, advice to all, who are students of Bar Council written exam or prelim. But coming soon written exam, I hope that always 2 or 3 hours for your writing for being expert or be perfect. Writing is skill most important. By writing, and it will be added in daily routine. Add your daily routine 2 or 3 hours for writing every day. I hope that after 30 days 100 hours for writing, fixed for writing. I hope that your writing skill is good or better than each other or previous life, because you know about the sections but never written, but not capacity to write the analysis the sections, ingredients of the sections never come or not get or carry the marks from the exam, because writing skill, this is very essential to carry the marks from the Bar Council written exam. And we launch special batch for Bar Council written exam. Having interest to get the registration as a member of Sharul Academy, I hope that first time get the success in your life and being lawyer in your life. Actually, read the sections, then memorize in your memory about the sections, then analysis, then writing in paper. Daily practice. I hope that improvement or improve your skill, writing skill, and hope that to connect the sections and increasing the capacity to analysis the increase of this section. This is very important for the purpose of the law. We have been the moral principle which is general held to underline the criminal law is that the state authority to punish requires subject to have had the capacity or fair support or to the law. The principle is reflected to a limits extent in the law of defense, where where as duress, insanity, and responsibility provocations many relieve a person from criminal responsibility. Actually, having responsibility of the accused under section 302 murder, act done by him, and relevant documents prefer that and prove that there is the options to chance doing act by him because accused and victims are friends. Actually, accused offer to victim marry, but victim is girl and she is not interested and deny the offer of accused, and then creation bad relations and bad sense against the victim. This is the main fact of the case. How to analyze the question? Actually, ingredients of this section and offense act done, and there are the sufficient grounds of the case, and those prefer that and eyewitness get the eyewitness of the case, and it is identified that being guilty the accused to kill the victim for the purpose of the affair. This is the reason of the section. Then clearly identified this is murder, and it will be applicable, this sections applicable against the accused because he is directly connected and kill the victim for affair, because he sometime offered to marry her. She is school going girl and not interested because deny the offer of the accused. This is the main fact of the case, and creation bad relations between victim and accused, and one day he prepared and to kill the victim in open field. There is no another person present there. This is the murder, and allegations of the section under section 302 of Penal Code 1860. And I hope that Bar Council written exam coming soon, and advice to all students, practice writing daily 2 or 3 hours. I hope that after 30 days or after practicing 100 hours, I hope that your writing skill will be strong and get the success in your life and be perfect and intelligent capacity to carry the marks from the Bar Council written exam. And Sharalla Academy launched special batch for Bar Council written batch, and interested any person call me and confirm your seat, because there is limited seat of bar council written exam. Maliciously, we state that on a charge of maliciously causing grievous bodily harm with intention to cause grievous bodily harm. Maliciously add nothing to what is already present in the word intent. A person who intends grievous bodily harm must, in other words, cause it maliciously. A similar result must flow on a charge of wounding with intent to cause grievous bodily harm, where the charge is maliciously wounding or causing grievous bodily harm with intent to resist or prevent arrest. Actually, maliciously provide that grievous harm. This is foreign law, criminal law, using grievous harm. But Penal Code 1860 using the word grievous harm. Section 320 of Penal Code, changing the words harm or hurt. 302 murder. This is grievous hurt because it elements ingredients of this section identified that this is the grievous harm. And thank you very much joining with live sessions and stay with me, listening and watching me and my speech. Thank you very much. I am Advocate Sharul Kumar Roy, Supreme Court Bangladesh, and founder and director Sharul Academy. And this is the Legal Academy and Research Center, Law Research Center. I hope that my lecture will be assist you and your career, and for law students and for lawyers who are practicing in lower court or high court divisions, Supreme Court Bangladesh. Thank you very much. Good night. Namaskar.